For the last few years, we've had many developments in conveyancing and property transactions in Kenya. The Ministry of Lands is digitizing our land records. They've already started in Nairobi and Murang'a, and they are soon to move to Mombasa. But the winds of change have not been limited to the ministry. They're now in our courts. The Supreme Court has delivered 3 key decisions in the last 3 years. We have Dina Management, Torino Enterprises, and Singh Shemi. Today in chambers with Mohammed Muigai LLP, we have Lucy Kibachia, who's a member of our banking, finance, and real estate practice group. Lucy Kibachia is an advocate for 6 years. She's been in the game before these changes began. Today we'll discuss what she used to do before the changes and what is happening now. We also have Dennis Nkarichia. Dennis Nkarichia is in the dispute resolution practice group. He's also a lecturer at Kabarak University. He teaches data science and digital literacy. Interestingly, Dennis represented one of the parties in the Dina Management case and has an intimate knowledge of the facts. I will start with you, Dennis, and I'll get straight to it. Dina Management. 2 years ago, the Supreme Court delivered a monumentous judgment in Dina Management versus County Government of Mombasa and others. Some of the members of the audience are aware of the case. Others have a vague idea of what happened. You're one of the advocates representing one of the parties in the case. Please tell us in brief what the case was about and what the Supreme Court held.
Thank you, David. Dina Management is simply a case of an innocent purchaser at the coast who decides to buy a property from a friend. Upon purchasing the property, the county government raises an objection when they begin the construction process. Amazingly, the first owner of that property was the President of the Republic of Kenya, then the late Daniel Toroitich arap Moi. So when Dina Management sought to buy that land, they were under the assumption that this is a former president's land or due diligence would have been undertaken. Unfortunately, when the matter went to court, the Supreme Court held that whereas they held a title, that title was defective because at the outset when the land was allotted to His Excellency, President Moi, a part development plan was not completed as part of the process for allotment. So the Supreme Court proceeded to hold that whereby one of the prerequisite documents for allotment was not available, no valid and legally enforceable title could have arisen for Dina Management.
Okay. Now, what did the Supreme Court say you have to do in order to find out if there's a part development plan or if there's an issue with a title?
If you take a step back, when someone decides to buy a property, your very first step is usually do a search. So that under the Torrens Land registration system would be conclusive of evidence of whether title exists and whether you can legally seek to enforce it. But the Supreme Court said no. The test for you to claim that you have an indefeasible title is that you must go to the root of that title. Each and every transaction undertaken must have all the requisite procedures and formalities satisfied before the final person holding that title can claim to have a legally indefeasible title. If a single step or a single documentation is not available, then you don't have a title you can protect against the whole world.
Now, from my understanding of the case, doing a historical search, going to the root of a title, finding out if there was something dodgy from the moment the title was created, these sound like good things. I will expect my lawyer, Lucy, to do a search which uncovers anything wrong in the title. The Supreme Court seemed to be reinforcing my expectations. So I don't understand what the hullabaloo is about this particular case.
I would say the fundamental mistake or misapprehension that exists around the matter is simple. We have a statute that provides for mechanism of how a title arises, and that's the backbone of the Torrens Land registration system. And under the Land Registration Act, Registration of Titles Act, even the current Land Act, a search done at the registry is conclusive evidence of all claims and interest on that piece of property. So, but if you sit down and do a search, but ought ordinarily to be the end of all your due diligence under the Torrens Land Registration System. Now, the Supreme Court saying you go up to the root, it determines two core principles. If you remember, the Torrens Land Registration System has three principles: mirror principle, curtain principle, and indemnity principle. But mirror, what is in the search results is what is on the ground. Curtain, you don't need to go beyond the search results to ascertain the status. Indemnity, if the results are wrong, we will indemnify you. Now, when the Supreme Court says go to the root, it says that mirror principle is no longer operable because what is reflected in the title may not or may be conclusive evidence. So go to the root. Number two, it says the curtain principle. You should not look beyond the search results. The Supreme Court is saying no, go look beyond. So fundamentally what the Supreme Court did in effect, it's repealed sections of the Land Registration Act or the Land Act by requiring that the provisions from the search results are not conclusive. We can conceivably put it, but we are no longer in a scenario whereby the strict duties and obligations provided under the Land Act and the Land Registration Act are the prevailing legal regime. We now have duty and obligations beyond what statute requires. And if the Supreme Court deems it fit, but let's go beyond what the statute requires, we should have a recommendation for Parliament as the author of all legislations in the country to amend the legislation.
I believe there are a couple of challenges that are faced with any person who is trying to transact in land in Kenya. And that could possibly be the reason as to why the Supreme Court decided that don't just stop at the official search that you get from the registry. At least try and go deeper and see if everything checks out prior to you maybe making the decision that you want to purchase this land, or for you to feel satisfied that everything is okay with the property that I own or you hold as security as a financial institution, just anyone transacting with a property in Kenya. And a couple of the challenges would be sometimes you'd encounter missing records at the lands registry. You understand that our record keeping is manual. So many people interact with these records that are kept at the Ministry of Lands. So you'll find sometimes there are those devious people who will end up, because of something small on the side, might end up interfering with a file. And whatever is there or held in the deed file is what the registrar relies on to convey to anyone who approaches the registry, either for a search or for registration of any sort of legal document. Another challenge you might face is sometimes you might say that you have done a search over the property, but have you at least confirmed that this property exists under the Directors of Survey Office, for example? Because before a title comes into existence, where it starts, it's from the Director of Survey, where there's a registry index map or whatever kind of survey map that is available that brings life to that property, and for it to be sort of marked and numbered to be seen as property that has been alienated. So when you say, as much as there's the Torrens system that says on the face value, title and a copy of such should be prima facie confirming what it is, or rather the ownership of this property, as practitioners and conveyancers, ideally we go further than that, even before the Dina management case.
And that's interesting, Lucy, because it brings me to my next question. As a dispute resolution practitioner, and I think this also applies to Dennis, the Supreme Court seems to be asking conveyancers, to us, to go take an extra step, dig a little deeper. Was there any difference in how you are doing searches prior to Dina management, and how you are doing them now, or it's just the same for you?
In terms of the searches that we were doing, I would say there's a small difference or a slight difference. And that is because, say, for example, when the court says that you need to go as far as to the part development plan, the PDP, for example, like in the Dina Management, we were not going to that extent, at least because we are of the assumption that, say, for example, when you're dealing with an RTA title, there's a deed plan that is attached to the title document itself. That already sort of implies that the director of survey has cited this property, and this deed plan emanates from a bigger sort of survey map that exists. So to that extent, what we would do the normal inspection of the property. You send a surveyor to the ground. You will have a valuer go and do the assessment of the property. So the surveyor confirms the beacons and the area of the property and whether it matches what is written in the title document, because there's usually the area of the property. Then we would also do, for example, if you're dealing with an RLA title, you would do not only an official search, but also a green card search. A green card search will show you the previous entries that existed, because you know that under an RLA title, once you buy the property, what happens is a new title is sort of printed out for you. So you don't have the record of the previous owner that was there. The only way you can find that out and see what other entries existed prior to your purchase is through a green card search. So that gives you the roots of that title. So ideally, those things we were doing, I feel the biggest change is basically on the PDPs and how far we need to apply ourselves to confirm that before this issuance of title, there was proper alienation and there was the PDP that gave rise to the title that exists currently.
PDP, it's an alien term for most of us dispute resolution practitioners. Now, I want the members of the audience to understand how far back the Supreme Court is asking you to go as a conveyancer when doing due diligence. Now, if you can please explain to them the process from the moment land, it's public land now, and now it suddenly has a title to the first owner. What steps have to be taken before the creation of the first title?
To put it in simple terms, once there's interest, either through an application to, as it were, the Commissioner for Lands for alienation of property or property wanting to be allocated to an individual or whatever kind of request they have received, or from their own volition that they want to alienate land, the first step is usually the creation of the PDP. And by PDP, we mean a part development plan. In the literal sense, it's a plan made for a part of the property, just for it to have the demarcations and to bring it to life, to existence, from a larger area of where it exists. So that's basically what the part development plan is. And usually the process starts from the PDP. Then from there, then the registry index map that exists will definitely change if this PDP or the area that is we are discussing was not part of the registry index map. So the PDP gives rise to a change to the registry index map, which is usually a larger map of a bigger area. So the part development plan is usually for specific instructions and for a specific area. So you might only find that it's only this specific, say for example, the Dina property. That's the only thing that appears in that map. And it's for those specific instructions that the Commissioner for Lands, as it were, had received or had given out to the physical planner for them to prepare the PDP. So you don't stop there, but you rather start from it. Then now from there, once you have the map in place and it has been confirmed by the physical drawn by the physical planner, confirmed by the Director of Surveys, signed by the Commissioner for Lands. Then now it goes to the next step where it goes to the Ministry of Lands for now titling, for preparation of that title document.
This seem like activities which take place behind the scenes. Will you get these documents on a normal search?
Ideally, no. And in previous interactions, it's not the easiest thing to get a copy of a PDP. Not an impossibility, but it is a tedious job to try and get the part development plan. Maybe for the reason being that all this while, these things happen behind the curtain with the physical planner, where in terms of planning of the area, maybe the locality or whatever place it is, that's where they start from. What we see on this other side is usually the end result of a title, and which you take as the property exists, and that's where you leave it at. But now the Supreme Court is tasking us to go however far to how this property got into existence.
Thank you, Lucy. Dennis, I know I've made you wait a while, but we're back on you. The decision for Dina Management is slightly over 2 years, and you'll be the first to admit the facts were unique. Not all of us are going to buy our land from land belonging to former presidents on the first few rows of beachfront. Now, have there been other decisions by the Supreme Court where they've said the same thing when presented with different facts, perhaps?
Yes. Unfortunately or fortunately for practitioners, the Supreme Court here has had a measure of consistency on the principle. It's that it keeps pushing on new interpretations and scope of how that principle applies. Because if you come before 2010, it's an innocent purchaser for value of a property without notice of any defect gets a good title. In Dina Management, the Supreme Court says you will get a good title as long as you go to the root of title and prove there was no claim or no irregularity against that title. Now, you have the second case after that is Torrens Enterprises Limited versus the Attorney General. Now, the Supreme Court says you will get an indefeasible title if you have no notice of defect and you even go prove the location of that property, the existence of that property. And if that property exists and there's no claim against it, the Supreme Court comes back an year later in Shemi and another versus Tarabana Company Limited. And the Supreme Court says, wait. Even your claim, but there is no claim against your title, will only stand against an equitable claim. So, but if you're an innocent party, you purchase land without notice of a defect, the only defect being covered here is an equitable claim on that land. If there's irregularity, that cannot be covered. So, but pre-2010, if you have no actual constructive notice of any defect, you get an indefeasible title. Post-2023 Dina Management, if you have no notice of a defect and you went to the root of the title, you have all documentation, you get a good title. Then when you come to Torrens, the question becomes this type of root of the title you need to go to. It's not only documentation, you also need to go to the site, because Torrens was a dispute whereby there was private land converted to public land owned by the Nairobi City Council. Then it was being sold to a private party. But between becoming property of a Nairobi City Council, and the private entity, Department of Defense gets an enclave, a piece of the land. So but the Nairobi City Council sells the entire land to a private person. But Supreme Court says, if you had gone to the site, you would have seen that there was a DOD installation already on site. You would have seen there was correspondence between DOD, Ministry of Lands, and the Commissioner for Lands about that part. So irrespective, but you are getting this land from the Nairobi City Council, irrespective of you doing a search, if you had gone to Kograud, as Kenyans call it, you would have known there was a challenge to the full piece of land you are getting. Now, instead of stopping there, they come now as late as this year and say, wait a minute, you will only have a good title if you go to the root, Dina Management, you go to the site, Torrens, and suddenly this claim cannot exist against an irregularity. Your claim is only against an equitable remedy. Not to be a provocateur, but I expect that by the end of this series of litigation, the Supreme Court may decide there is no innocent purchaser.
That's very interesting, Dennis. I want to unpackage what you've just said, what the Supreme Court said in Shemi, and that's on the innocent purchaser for value without notice. Now, you say previously it was innocent purchaser for value without notice. Supreme Court said it's not without notice of irregularity, it's without notice of an equitable interest. Can you please explain to the members of the audience what's the difference is of without notice of an irregularity to now without notice of an equitable claim?
Thanks, David. Now, if you take a step back, say you are buying a piece of land, you do a search, you will expect that any and every transaction done on that property is recorded on the search results. Who was the first person to be allotted? Did they get a loan? Or did they discharge the loan? Did they get to someone else? So notice of a defect arises is if you get a search result, says there was 5 million loan from a certain bank as a charge. Then there is no discharge. And the person selling to you is selling to you freehold title without any claim. Ideally, you have notice, but there was a charge on this land, you ought to ask whether there is a discharge. Another example, you are buying land next to a road. And when you get your search results, you note maybe Wood Avenue is 5 meters. And the only road that has been demarcated on the search results, that the plan you can see, is 4 meters. You have noticed that 1 meter is a road reserve. So that's what the Supreme Court says. If you are going to buy land as an innocent person, you should not have notice of any defect. Now, these are legal interests, but registered on the title. Now, when you come to equitable claim, there can be a trust. If you find most of the community land in Kenya, it is held by one person for and on behalf of other people. These other people will not be registered, but will be expected to know of these equitable claims. Another example, if you are buying land that is going through what normally people call succession. Someone has died, as part of a family to raise some income to settle the estate of the deceased, they are selling the property. You will automatically be expected to know if the person who appears on the title is not the person selling to you, to ask, has the succession been completed? What else is going? If you are buying land from a company and you find it has very many shareholders, but only one person is driving the entire sale, you will be expected to ask the additional question, have all the other shareholders consented to? So these equitable claims are legal interests that other parties may have on that land, but have not been registered. So what the Supreme Court says in 2023 in Dina is you have a good title. If you can go through all the documentation until a PDP, the very first document issued in law to confirm every transaction has provided every document. But when you come to Sacharan Singh Semi versus the Tarabana Company Limited, the Supreme Court says, number one, go up to the root, Dina, find each and every document of a transaction. Now, number two, are you aware of any and every equitable claim on that piece of land? And have you made sure no claim exists against the intended transfer? And hence my position that we in Kenya used to have a person called an innocent purchaser, the man at Muvurwa who intends to buy a piece of land back at Kamulu. Now, you go to the registry, you get search results, you proceed with the transaction. Supreme Court says, no. Go to the registry, get search results. Then hire someone to do diligence from the very first time, because all land is public land or community land. Confirm how this land is being converted to private party, then how the private party has transferred up to you. Number two, go to Torino, go to the site, confirm any other circumstances of the ground that are inconsistent with the results of your search. Then number three, confirm is there any possible equitable interest that could exist on this land.
Thank you, Dennis. That was a very wonderful explanation. Now, Lucy, Dennis mentioned Torino, and one of the less controversial findings in Torino is that an allotment letter does not confer a transferable interest. Now, we all know there are people who transact in allotment letters, especially in our rural areas. Now, first question, do you agree with what the Supreme Court said on allotment letters in Torino? And secondly, how would you advise someone who has an allotment letter to transfer their interests, so to speak?
Firstly, yes, I do agree with the Supreme Court, because you having an allotment letter is just but the initial stage of your process of getting a title over that property. So as you're holding that allotment letter, you'll find that there are usually conditions put there, either restrictions, conditions, and some statutory fees that you need to pay to the ministry. That is for you, or rather to allow you to start the process of now the ministry coming up with that title document over the property. So you might look at it in the light sense of an invitation to treat. It's for you now to take that next step of now following through and say, okay, I have this allotment letter. There are these fees that have been listed here as payable. So you go ahead and pay that, and then now start the process of the titling. And briefly, just to mention what it is you need to do after confirming the fees and the conditions, after meeting those conditions and paying the costs that have been tabulated on the allotment letter, what you do is now go to the National Land Commission and say, I want now a title document to this property that was allotted to me. So they start from the, say for example, if it's a deed plan that is prepared, so they confirm from the survey's office again where the route of all titles should begin from. There is that survey map. They confirm that the property exists on the ground. Then those documents are brought to the National Land Commission. Then they do prepare a lease document. Then that lease document, once it's signed by the parties, which the proprietor who's coming in usually signs on that lease document, then now that lease is forwarded from the National Land Commission to the Ministry of Lands for issuance of that title document as we know it.
Perfect, Lucy. And what I get you to be saying is, unless you have a title, you can't transfer it. So if you have a letter of allotment, you need to take the necessary steps to turn it into a title and then transfer it. Okay. Coming back to you, Dennis, you go to court every day, and some people say that you are widely read. That's what they say. Now, following the Supreme Court decisions in Dina Management, in Torino, and in Semi, how have the Environment and Land Court and the Court of Appeal reacted? Have they followed the lead of the Supreme Court? Have they tried to distinguish the cases? What's your...
On a balance of probabilities, and from my experience, which may not be universal, is you find that there is a distinct uneasiness by the Environment and Land Court in enforcing the parameters of Dina Management, Torino, and Semi. Because predominantly, what I've seen happen a number of times is the courts will agree with the principle, but you can only get an indefeasible title if you get the title free of any defect, free of any notice of defect to the notice, and against any claim that was made against that title that you have acquired. Now, at the factual evidence, the trial court, usually the Environmental Land Court, you will see they tend to agree on the first issue, that a buyer who purchases property unaware of any defect is entitled to an indefeasible title. Now, number two, when they come to the question of what defect should you have notice with, you will find that the Environment and Land Court has consistently tried to materially and substantially differentiate each and every case from Dina Management. So that Dina Management is good law, and it's good law to the effect that if you have notice of a defect on your title, you would get a good title. But what amounts to this defect? Now, we'll find that in Manengo and Anava versus Kaindi and two others, the court goes to great extent to say, well, you have claimed there's a defect in the title, the evidence you have provided is not adequate to prove fraud. Now, for the audience will appreciate that fraud is semi-criminal in nature, in that fraud is not strictly speaking civil, is not strictly speaking criminal. It sits somewhere in between the two. So similarly, the evidence that you have to prove is beyond a balance of probabilities, but below reasonable doubt. So most courts, when trying to distinguish Dina Management, will say the evidence you have provided to us is not adequate to prove fraud. So if it's not adequate, then you get the purchaser gets a good title. Secondly, another track record we'll find is that in Mwaura versus County Government of Tanzania, the Environmental Land Court takes still the question of how much evidence have you provided and how are we to assume someone has notice of a defect. So they keep holding and reiterating, but Dina management is valid law. But the courts appear hesitant to strip someone of a title, but they appear to have followed all due process in acquiring that title just because of a technicality. For those of us who believe in the spirit of the Constitution, we believe the two can sit side by side because it's the court trying to protect economic interest without giving undue regard to technicalities. And it's the same spirit that you see the Supreme Court trying to uphold. It's just that at the trial court, until now, I have not seen parties who have adequately canvassed the scope of how do you prove someone has notice of a defect and how do you prove that that title is faulty.
You mentioned two cases. Were they both by the ELC court?
Yes, one is ELC at Trans Nzoia and the other one is here.
Now, what I take you to be saying is that the ELC court is saying, yes, Dina management is correct. We are bound by the Supreme Court. We're going to apply it. But it's using the flexibility it has with the facts before it to distinguish the facts. Is that the... Thank you, Dennis. Now, Lucy, you practiced prior to these decisions, and you've already told members of the audience that you already did a deep dive into the history of the titles which are presented to you by your clients. Now, not every advocate did that, and it wasn't necessary. Sometimes a search was enough, and they did transactions, and there are people out there who have titles which the only due diligence which was done was a routine search. Some of them may be scared by what Dennis is saying, that there may be irregularities in their title which may affect their validity. Now, what's your advice to them? Should they panic? Should they take their titles and do something about it?
If they're watching this and they know Mohamed Muigai, they have no need to panic. What they need to do is come to us, say they're a bit concerned about maybe whatever it is that they hold or a property they're interested in, but they would like us to do proper due diligence on the property before making that decision. And if it's a financial institution and they already hold property as security and they feel that they're a bit concerned about the root of the title or non-payment by the borrower for whatever reason, that is also something that we are able to do. Might not take away their risk 100%, but it will give them better sleep knowing that whatever it is that we hold and whatever we stand to lose, at least we know that this is proper title that we are holding. So ideally, in terms of the due diligence, I would say we have been doing it in depth just for abundance of caution. We would have stopped at the search before the Dina management, but then that is not where we ideally stop. We go further than just the official search in terms of even looking at, say, for example, the historical search. And if it's property that is in an area that probably is adjacent to a river, then we also do checks with Warma for them to confirm that this does not form part of riparian land. So I believe that due diligence gives you that comfort that this property I am holding is at least 100% legit, as what the Supreme Court is now having us do currently.
Back to you, Dennis. These problems seem to come from the Lands Registry. I do a search. They tell me it's authentic. I buy the property. It later turns out to be fake. They are clearly to blame. Why aren't they being held responsible? One of the principles of the Torrens system you explained earlier was indemnity or stroke insurance, that I am relying on the registry, and if anything goes wrong, the registry indemnifies me. Now, you've read all these cases from the Supreme Court. Have they said anything about the registry?
Yes, but they have not addressed the core argument or the core issue that practitioners have. To one end, the Supreme Court consistently says this registry has a duty to ensure the records are accurate, but you as the buyer have a higher duty to go and confirm. It's a trust but verify, a doctrine that international diplomacy will be well aware of. Now, as a practitioner, the difficulty you find, and I will say from Dina Management, there was a clear attempt at seeking indemnification from the registrar of lands, of titles, because of one very simple thing. When Dina got back land, for over 10 years, they paid land rates. The county government, who was contesting the title, demanded rents, and the rent was paid to the county government for over 10 years. And even the buyer before, Messrs. Bewaziri, who bought it from President Moi, paid their own rates. They paid the land rent for more than 10 years. So for you to come and claim that this title is questionable, you will find that there must have been an error fundamentally done by the registry. So at the High Court and Court of Appeal, people will always seek indemnity from the registry or from the lands registrar, registrar of titles, or not even from the ministry itself or the AG. The challenge that arises is once you are done at the Court of Appeal, there are only two ways you can approach the Supreme Court: interpretation of the Constitution or an issue of general public importance. Now, since clearly your ownership, you're not seeking to interpret the statute or the Constitution, will fall under the second rule and for certification to the Supreme Court. For you to certify, you must provide the specific questions you want the Supreme Court to address and show how those issues transcend the interest of the parties. So once you have a decision from Court of Appeal, you have to convert it into issues of general public importance. And that's where the indemnity falls or fails. Because the moment you are seeking indemnity, but a specific remedy between the parties to the suit, it is not a remedy against the entire world. So you will find, in some experiences I've personally had, the Court of Appeal will grant you the very first 1, 2, 3, 4 questions you have. The moment it gets to indemnification, it is no, this is not an issue of general public importance. Or if the Court of Appeal denies you certification, you go to the Supreme Court, we'll find that they certify your issues, but will not certify indemnification. The effect of that is you cannot plead, you cannot argue anything on indemnification, because the Supreme Court has consistently held you will only argue and the Supreme Court will only address the issues that were certified. Now, after some thinking back and forth with my seniors, we have discovered it might be possible if you appropriately frame your question from the word go. When you lose at the High Court your title, when you're going to the Court of Appeal, you have it as a simple generic question. Is a party entitled to indemnification? So, but when you're seeking certification from the Supreme Court, you now frame it as a broader question. I've not seen anyone who is yet to have framed it to a Kenyan Supreme Court, but I know instances in other jurisdiction where once a title is nullified due to mistakes, errors, or omission attributable to the registry, you are indemnified the market value of the property.
So it means that there are still some questions around this issue which the Supreme Court is yet to answer, and only because it hasn't been framed in the right way to pass through the narrow window to the Supreme Court.
That's correct.
Now, Lucy, we've all heard of Ardhi Sasa. This is a digital registry for Nairobi, Murang'a, and I hear it's expanding to Mombasa. Now, before the registry, and I understand that there is a verification process before my title goes to Ardhi Sasa. Now, before the registry verifies my title, does it do this historical search the Supreme Court is asking you to do? And if it does that search, does it ease the burden for you as conveyancers?
How I'll put that answer is the registry is expected, whatever it is that is on the hard copy deed file that is deposited with them at the registry, everything is uploaded onto the platform, then forms part of what now is your property that you can access from the end user side, having confirmed and verified all this information. And by verification, I mean that if it's a title that's owned by a company, they have confirmed from the records that are held at the company's registry that this is a company registered in Kenya. They confirm everything is in order. Then they also do the other step of the National Registration of Persons, Registration Bureau. They confirm the existence of this individual so that at the point where they're uploading this information and they have enumerated it onto their platform, then they have confirmed all existence of the previous records, such that when you're applying for a search on Ardhi Sasa, there are two options. You might choose to have a simple search that only gives you the proprietor's details and the property. Then you have another option of search where you go to the roots of the title. So you ask for any encumbrances on the titles, just a proper detailed search over the property. So what that gives you vis-a-vis the one that just gives you the proprietor is that it's going to show you all the previous owners of that property. It will show you all the encumbrances that were ever listed there. So you have a sequential search showing all the records in that subject property.
Okay. I think that's very enlightening. Now, Dennis, Ardhi Sasa was created to deal with issues which plagued the manual register. And from what Lucy has explained, it has pre-verified historical information. And this sounds like it's much more reliable than the manual system. Now, the question for you, does Ardhi Sasa change what is required of Lucy as a practitioner post-Dina management? Can I go to a court and say, I did a historical search to Ardhi Sasa, I got all this information, this is sufficient?
Unfortunately, no. Because to start off, Ardhi Sasa was introduced through regulations. But regulations cannot supersede an act of parliament. So what you have in the hierarchy of laws, you have the constitution, that provides for the right to property. Then you have various statutes that provide for how the right to property arises and how this right is transferred. For an example, you have the Land Act. Now, what the Supreme Court says in Dina Management is it's not the end game, just checking who has the property and who the property was transferred to. Is ensuring that every form, every technicality, every prescribed form in statute that was necessary for a certain event to occur, occurred. What I hear Lucy to be saying is that you'll be able to find a large portion of the history of the documentation kept by the Ministry of Lands. Part development plans do not exist at the Ministry of Lands. These are documents that you get from the Director of Survey. So unless and until Ardhi Sasa is merged with other government department so that it gives you conclusive, holistic documentation, you do not have any defense, you do not have any solution. Secondly, if you step back, if you go to Ardhi Sasa and find, let's say, information, but tells you this land has XYZ interest and rights registered over it, someone goes and comes with the actual physical documentation, and now you have a dispute in court, which regularly happens in court, where two parties have two different documents. My understanding of the legal regime is that because the documents provided for under statute are the physical forms, the physical forms will become primary evidence. The output that you get from Ardhi Sasa, being an output that is anchored on regulation, not statute, will become secondary evidence. And as such, Ardhi Sasa might help, but I would never imagine it replaces or substitutes the actual documentation envisaged in statute. So the only way for us to get more courage, for us to rely more and get more comfort from Ardhi Sasa is they go back and amend the root statute, which is the Lands Act, to ensure that it also has a mechanism whereby it's an option or an alternative. Right now, it's just a backup. It's not an actual option to what I would say is the currently existing legal framework.
Lucy, then he says your work is not easy. You still have to do a deep dive into the historical records. And secondly, you have to do a wider search than what you can get from Ardhi Sasa. Now, sometimes the information you require to do your search is found in other offices outside Ministry of Lands. You may have to find if there's a road reserve, if there's a rail reserve, if there's a market there. How do you do it now in properties which are already under Ardhi Sasa? For instance, Nairobi. How do you do the deep search?
I do agree with Dennis. I cannot stop at the search that I get from Ardhi Sasa because that's just the beginning of it. I would still have to go to the Director of Survey to confirm on the map, does this property exist? What are the demarcations of it? With the Dina Management, I am expected to go to the physical planner's office and try and procure a PDP. So ideally, as much as what Ardhi Sasa is trying to solve, I don't think is making our work less in terms of doing proper due diligence. Rather, it's for you to be able to access these records on the go. For example, as a property owner, as someone who's interested in purchasing property. So, for example, you want to put in an application for a search. Ideally, physically, you would only go to the registry between the hours of 8 to 5 p.m. But right now, at the comfort of your home, you log on to Ardhi Sasa platform and request for a search. As long as the owner on that other end verifies that I know David wants to procure a search because we're in the talks of him buying the property, he verifies that search application and you get your results real time. Definitely having paid the government invoice on the statutory fees applicable. So I don't believe that Ardhi Sasa is here to make our general due diligence less tedious, but I think it's more of convenience and maybe record keeping and having those pretty accessible to Kenyans in general.
Dennis, it's very fortunate that you lecture in data science and digital literacy. The system Lucy is describing seems to be a hybrid system, part digital, part manual. Now, what suggestions will you have for a digital system which is reliable, which we can confidently go to, get records for everything? Similar to Google, I search this property, it tells me this is the history of the property from the moment it was public land. There are no, it's not riparian land. There are no road reserves on it. There is no issue. There is no irregularity, as the Supreme Court calls it. Is there a way we can achieve that?
Achievable, yes. But it calls for what you call a whole of government approach to the issue. So, but rather than doing siloing, where Ministry of Lands has its own platform, the physical developers have their own platform, the Director of Survey have their own platform, you need to provide a system that integrates all these data. So the most critical element is you need to map out the overlap areas. So that if you know it's Ministry of Lands, you also need Director of Survey, you also need a citizen to process the payment. You may also require the physical planning department. You will also require Warma to see what is our water reserves, Kura, Kenya to see road reserves. So you map out who is a stakeholder in this engagement. Then upload all their documentation and then subsequently avail them to the public. But from a data science perspective, the most critical element that the privacy of government doesn't allow us to appreciate is a very simple question. Who owns Ardhi Sasa? Who operates Ardhi Sasa under the water modality and framework? Because it's critical in Kenya, where a citizen has a right to privacy, where we have a Data Protection Act, but all the information held there is protected to the highest standard possible to avoid malicious actors. You see, today, if you have a physical copy of my title, even if you tear the one you have at the registry, have a backup. If we move everything online and someone has super use and admin access and can alter those records without an auditor being left behind, then we are at the mercy of that person. So security will be the greatest concern that the government must address. Given recently you have seen data leaks in other countries, even some BRS information being publicly available, it's really critical we address privacy. Now, number two is what we call the digital divide. There is a presumption in Kenya that everybody has a mobile phone, but everybody has an internet-enabled phone. It's a very wrong presumption. If, as litigators over time, we have found that going to physical court helps because some of our clients cannot afford phones. We must recognize, even in the conveyancing sector, some of the clients will not own phones. Now, what I've seen for Ardhi Sasa is you must have a device that can enable you electronically sign. That's not possible for everyone. So if the government wants this to be a success, then you have to go back and remember we have Huduma centers. Do we ensure we track and trace them up to the sub-county, sub-location, chief's office, so that we don't have an urban centric tool but only assist and helps people in urban centers still a match against the rest of the populace? Now, immediately you have that issue and you address the issue of the digital divide and accessibility. Then you come to the issue of, do we adopt a blockchain approach to record keeping and record management, or do you want to adopt a democratization of record management? Now, what blockchain will do is the information will remain private, and any subsequent alteration will require everyone in the blockchain to approve it, so that you protect against malicious unilateral actions, because you need all stakeholders. You will require the ministry, maybe the director of survey, maybe the owner of that property to approve before any change happens in the blockchain. And then that record is universally kept by all the parties to the transaction. That's a great security. But is that feasible? If it's not feasible, you do what you call democratization. You ensure that you map the entire country, avail all those records freely accessible on search. The same way someone can freely do a company search, you then become freely able to do a search of any area of land in Kenya. Now, that will pose the privacy concerns and the safety concerns I raised earlier. So, as we try and adopt Ardhi Sasa, the question that we ask ourselves, what framework are we using? What model are we using? And finally, costs. There is an assumption, very flawed, that internet things are cheaper. But you do your Google search, it's free. You just need an internet connection. Now, what very few people appreciate is the substantial costs that must be undertaken. So that you, first of all, need to deliver the physical hardware that will enable the whole country to have access to an internet connection. Number two, you need the infrastructure to store all these records. Number three, you need to be able to maintain simultaneous connection. If you are ever tried to use the e-filing platform for the judiciary, very early in the morning it's very slow because there are so many requests per second being made to the system, it slows down. Ardhi Sasa, if you are doing it for the entire country, you can imagine how much downtime you'll have. To ensure we don't have downtime, to ensure there's consistent accessibility, irrespective of geographical location, will require the government to undertake substantial investments in technology, infrastructure, and even public engagement. Because if you do this without public buy-in, you will never be able to have a successful project.
Thank you, Dennis. That's a very detailed explanation, and we're very grateful for that. Lucy, what Dennis says seems to be that fully digital is very hard, it's risky, and we need to put in a lot of effort and a lot of money as a country. Now, I just need your takeaway from this. What do you think is the best system for Kenya? The manual system that we've had since independence, which has given us a lot of problems, a digital system with its risk, or a hybrid system which embraces the advantages of the two systems?
I think there's no right answer to that. And it's because I believe there's no system that will not have challenges. If it's the digital, there's the issue of the admin today decides to alter anything, is pushed to a corner somewhere and has to change some records. For the manual one, there's also the risk of those are hard copy records. There's normal wear and tear. There's fire. There's interference by the employees at any of these registries. So a hybrid might be an option that can be considered, but then I feel like the right answer would be whatever way we decide to go, let us first look and see what challenges might we encounter and how do we counter them before they hit us. So I personally don't think Ardhi Sasa is the worst thing that has ever happened for Kenya, but I am not sure how ready we are in case there's any sort of alteration to what we think we have and the foolproof system that the government has put up with the Ardhi Sasa, and because of the concerns that Dennis has raised. I mean, so who has control of all this information that sits there? But then also, I think the audience needs to know that as much as there is Ardhi Sasa and that you'd be able to log in and see your property there, at the end of the day, you still hold your physical title. That has still not been taken away from you. So every other day, if it's under your mattress, you can go look at it, confirm, I still have my title. What Ardhi Sasa does is you go onto the platform, under my properties, there's a section called my properties, you confirm and see, okay, my Nairobi block property is still with me. So ideally, Ardhi Sasa currently sort of complements what is there and what has been in existence. Another advantage I feel there is with Ardhi Sasa, I think there's a bit of convenience it brings along. In terms of you being able to access this information past government working hours. But also, I think another challenge that people should be aware of is for the people who had the RTA titles and were gazetted to convert the property to now onboard it onto the Ardhi Sasa platform, they are our parents and our grandparents. There's that generation where they don't have a physical signature like we do. So what they do is the thumbprint. What that platform does not allow that to be done remotely. You have to go to the Ministry of Lands. That individual, however old, has to present themselves in front of a registrar, confirm that they are the owners of that property, then their records are taken and the thumbprint is taken as their signature. Because you know that on Ardhi Sasa platform, every transaction that is done, there is a signature you input. So for this person to be able, so for them, it will not apply that way because there's nowhere that allows for a thumbprint to be put. So what they placed the first time is what will continue being their signature. And what they would get instead is just the OTP confirming. So you also see the challenge of, is my grandmother able to internalize and to understand that this OTP is timed? If I ask her for that OTP to assist her do a transaction on the platform, does she understand she needs to convey that information to me immediately before the OTP expires? Then we have to prompt the system again. Another issue would be she's there with a caregiver or whoever is next to them. How do they have their interest? Is it possible that you might get onto that platform, coerce them to sort of move any sort of property to you without them really understanding what it is they're doing? So there are those small challenges that are there, and I don't think that discredits the whole system. But then, as I mentioned, we need to foresee what challenges we would face and try and work on them before or as they arise.
So there's still some work to do on Ardhi Sasa.
There is some work to do.
Not everyone may know that they have to take a step in order to be in Ardhi Sasa. Can you just, and this is the last question, can you please explain to members of the audience what regions titles being converted for Ardhi Sasa, how they can find out that whether their property is up for conversion, and if you can help them in that process?
Before I go to how they can be onboarded onto the platform, it's prudent for me to mention that currently anyone transacting or rather paying stamp duty for whatever transaction, the government has communicated that you need to have an Ardhi Sasa account. That is despite you having property within the regions that they have already onboarded onto the platform. So we would advise, yes, this is countrywide. If you're transacting in any sort of property, then you need to have an Ardhi Sasa account for payment of stamp duty, because stamp duty is now being collected collectively through the eCitizen account. So that is for everyone, whether you're within Nairobi or the regions that have already been onboarded. Then on how you get onto the platform, yes, it is something we can assist, although it's also an easy way of registering. It's like opening an account. They do have a YouTube link of how to do an individual registration on Ardhi Sasa. We also welcome our clients to come in, and we would be able to assist them to open an account. But ideally, it's just a set of questions that they ask, sort of what you went through opening an eCitizen account. You need your official national ID for Kenyan citizens, and for foreigners, but who are transacting within the country, you can equally have an Ardhi Sasa account. You will, on the platform, the Ardhi Sasa app, once you open their website, there is a chat button. So you tell them that you're a foreigner and you want to open an Ardhi Sasa account. So they ask you a set of questions and they ask for certain documentation. Then that process is done from the back end. So they will email you and say they have received your request. Then they will give you a set of questions or whatever other information they might require from you. And that account is opened from their end. That is because the system as it is right now only accepts or only knows national IDs. So if it's a passport you're using to be onboarded, then that has to have the back-end user, the IT department, to help and onboard you onto the platform. So currently, Nairobi properties are the ones that are fully on the platform. Currently, they are enumerating Murang'a, and I believe the next registry or section of properties is Mombasa. So the government is doing it in stages so that you don't, for commercial reasons, you don't sort of bring to a standstill all the transactions that are ongoing in the country. Yes. So just before end, if you have property in Murang'a, you can come to us and we assist you to have the property now verified onto the platform.
That's Nairobi and Murang'a.
Nairobi, I believe the chunk of it is done, unless your property had a certain issue and had not been gazetted or had some boundary issues at the Service of Kenya. Otherwise, all properties should ideally be on the platform right now.
Okay. Now, Dennis, the Supreme Court has said what it has said. It has defined who an innocent purchaser for value without notices, according to it, and that's the final word. Lucy and her fellow practitioners have had to now go deeper into the searches that they are doing. What's next? The question goes back to the Supreme Court. Parliament does something about the legislation, or we still carry on with this mongrel of system that we have?
I would say there are 2 points of departure that should wake someone who really engages with the land tenure system in Kenya. The first issue is the Supreme Court has set out jurisprudence and its own precedent on the Muruatetu case, but it's not for the Supreme Court or the Court of Appeal to set public policy. It's the avenue of Parliament, and that question of whether death sentence is applicable or inapplicable in Kenya. The Supreme Court was emphatic, but that's an issue for Parliament to decide. I would also suggest to the Supreme Court that the issue of the duties and obligation of parties in a land transaction should be for Parliament to set, because the more and more the Supreme Court keeps interpreting this duty that an innocent purchaser has, is more and more, as a practitioner, I come to one simple question. Does the court appreciate that it's making a public policy choice for Kenyans? Because there are 3 main types of land registration and land management systems in Kenya. In Kenya, you have heard of Torrens, there is a cadastral system, and then we have the deeds registration system. Cadastral system is whereby land is nominally appears in blocks, but are usually color-coded. You might have done it in geography in high school. The deeds registration system is what you have in Ireland, Hong Kong, whereby from the moment a piece of property exists, each and every transaction on that piece of property must be registered in a government registry. So if you want to do a transaction on a certain piece of land, you would require the seller to provide for you all the deeds, all the instruments ever registered on that piece of property. Then you make a call whether that property has a good title or not. That's what the Supreme Court seems to be saying. But Kenya, we are not a Torrens system where the results of a search from the registry is conclusive. We are a deed system. Go and find each and every document since that land existed. Now, I will suggest it's not the place of the Supreme Court to make that decision. We agree the Supreme Court has a duty to enable the society, cure the problem that we have noted of the shortcomings of the registry. But in playing its role, it should not make a policy choice. Second issue that arises from the decision of the Supreme Court is that if you make a policy choice, you must make it within confines of economic reality. Now, countries that have adopted a deed system, I gave you an example of Hong Kong and Ireland. In Hong Kong, you just need to prove all documentation up to 15 years. In Ireland, you need to have all the deeds for the last 20 years, and a party cannot insist on the deeds beyond 40 years. So, but these courts recognize that if 10 years, 15 years have elapsed without a challenge on this title ever arising, then you have slept on your rights. You can't now seek to invalidate. Why am I saying this? And I say this with utmost respect. Kenya is not a paper-friendly country. Number one, we have had natural calamities whereby maybe there's a flood, my title goes, all my documents were in a folder, they are gone. Number two, there is a fire outbreak, all my documents are ashes. Now, under the Supreme Court approach, then I will be sitting on a piece of land, but I cannot prove my ownership because maybe the PDP, maybe another related form of documentation, but had to be filled in 1980 by my grandmother, is now no longer in play. Another question, let me ask, and I will put it in the kindest way possible. Land registration in Kenya began in 1890. If you are to go to the title of all land, but were issued titles under the Imperial British East Africa Company, you will go to 1890. Then this land, in 1920, we get the British Protectorate and the British colony arises. There's a change in law. Now, after 1963, there's another fundamental change in law. So what would happen is if your great-great-grandfather got a title in 1901, that title is no longer legible. The words have been just operation of time rubbed away. Now you are no longer able to prove what interest was allocated to you. If you strictly follow the Supreme Court, is you have nothing but a piece of paper. But that's not the reality we live in today. So my word will be, if we are to insist on this route of title, should we consider having a time cap? And lastly, it's a question that practitioners always argue. If my client relied on a deed, on a document from the registry, and they paid money for that land, if they are to lose their land because of errors or omissions of a public servant who deliberately, willfully, or otherwise ought to have known of the error, then they ought to be indemnified. So, and it's a joke that runs along for litigation. There are litigation matters you handle, and you hear the party representing the registrar, and people smile because there's some nefarious actors in the system. If we made people personally liable for any blatant mistake, any blatant omission within the registry, we may find we are able to cure the defect that currently exists. So rather than supplant the legislative mandate of Parliament, maybe personal responsibility and liability for nefarious actors will be a more statutorily, common law, and common sense approach to the issue. Thank you.
Now, that comes to the end of our talk today, and I would like to thank you truly for making the time to come here. I think we've all benefited from your experience and your knowledge on the subject. It's a deep topic, and we've only skimmed the surface. We do hope to continue this conversation another day.
We are happy to come. Thank you for the invitation.
Thank you for having us.
On behalf of Mohammed Muigai, we'd like to thank you for tuning in to this podcast today. And we'd like to remind you we're available on Spotify and YouTube. Please continue tuning in for more interesting topics from us.